Well, I'm Ellie Krug, and I'm really thrilled to be here again for our training, our fifth training session for the Call for Justice and United Way 211 collaboration. Our speaker today is Larry McDonough. He is the managing attorney of the housing unit at Mid-Minnesota Legal Aid in Minneapolis. Larry has been a legal services attorney in Minnesota since 1983, where he focuses primarily on housing and consumer law, and he's done that since 1986. In his career, he's co-founded Minnesota's annual Housing Law Institute, and he has authored a book and several treatises on landlord-tenant law. He teaches a housing law clinic at the University of Minnesota Law School, previously taught poverty law course at both the University of Minnesota and the University of St. Thomas Law Schools, and he's also taught evidence at William Mitchell. He created the very first landlord and tenant law course in Minnesota. He has received many awards over the years, including the 2008 Minnesota Justice Foundation Distinguished Service Award, the 2004 National Lawyers Guild Minnesota Chapter First Annual Paul Marino People's Lawyer Award for his work as a tenants attorney and a teacher, and the Minnesota Law and Politics Super Lawyer Selection. But before becoming attorney, Larry taught high school band. He has been a professional jazz pianist for over 40 years with several CDs under his name and regularly performs throughout the Twin Cities, including at the Dakota and this weekend at the Basilica.
Right.
So help me welcome Larry McDonough, please.
Thanks. Yeah, I don't know. Did I do all that stuff?
You did.
Okay. So, here to talk about landlord-tenant stuff. I hear quite a few of your calls are related to landlord-tenant. That doesn't surprise me. Pretty much anybody that does service with folks that are on the poorer end of the spectrum get a lot of landlord-tenant questions. That's the same where I work at Legal Aid. If you'd ask the people at Homeline, they'd say the same thing. And so I'm happy to talk about it. It's been really fun practicing in this area for as long as I have. I've really been doing this practice for about 25, 26 years, which you'd think would be a little dull after a while. But as you know, every call is different, right? And it's the same thing in my work. And it's like every case is different. And it's fun to be, I've sometimes talked to students and they go, well, isn't it a little depressing just to see that they're poor people every day? And it's like, well, you know, I mean, there were poor people before I was born, there'll be poor people after I die. And the question is, so I can't like change that, but can I do something about it while I'm around? And yeah, you can. And so you do little things here and there. Every person that you help is maybe a little closer to having a better life than before they talk to you. So that's what makes it fun. So we're going to talk about landlord-tenant law. I've got the outline that you guys have, Ellie and I put together, and so I'm going to work off of that. I'm not going to do it word for word because that would be really boring. And feel free to ask questions. And you know, if you're an unruly bunch, which I don't expect you to be, but if you're an unruly bunch, I dislocated my toe recently, and I get to wear this boot now and then, but it works as a great gavel. So if things get out of hand here, the boot comes out. So, okay. So and I've got some questions that people have put forward before this, and I'll deal with some of those questions as I'm going through this, but feel free to ask questions. I'm for any of you that know birth order analysis, I'm the third born of 3 boys. So you're probably going, oh, he's the random one. And yes, I am the random one. My oldest brother, I'm 56, he's 60, probably still wonders how I get dressed and get out the door. But anyway, what it means is that you can interrupt me anytime and I'll float back to where I was. You know. And I'm also the father of 3 daughters, and so you know, you can yell at me and that'll get my attention and I will respond. So hopefully that didn't sound too sexist. I know boys yell a lot too, but my girls were always pretty vocal. So let's talk a little bit about leases. I'm going to try to dispel some misconceptions while we're going today. And the first one is that, well, you only have a lease if you got something in writing. That's wrong. A lease is a relationship. It's a relationship between a landlord and tenant. It actually stems from the phrase a leasehold interest in property. So it's a relationship, it's not a thing. Okay? The document is a written lease, but you can have an oral lease too. So if anyone tells you they're a tenant but they don't have a lease, they're thinking they don't have a written lease, but their relationship is a leasehold relationship. There really aren't any big differences between oral leases and written leases. The only real difference is it's harder to prove the contents of an oral lease. And so for the protection of both landlords and tenants, it's a good idea to have things in writing because they can say, well, you said I could have a pet. No, I didn't say you could have a pet. Well, if you got the lease, then at least there's something that both sides have signed that either say pets are okay or they don't. So it just makes it harder to advise people on what their rights and obligations are if it's oral, because their recollection might be different than their landlord. But otherwise, no big difference between oral and written leases. There are two main types of leasehold relationships. Again, written and oral is really just the form of it, okay? The actual type of relationship, the most common ones are a month-to-month and a term relationship or a term lease. So a term just means it goes for a term in time as opposed to the term being a provision of a document. So most common term lease would be like a 1-year lease, but you can have 6 months, you could even have 39 days. It could be anything, right? Oral leases can be for a term, and written leases can be for a term. Okay? Again, no big difference between the two. Now, the most common other lease, besides term leases, is what lawyers call periodic or at-will tenancies. You don't need to remember that. It's a tenancy that doesn't have an end. The end is created later by the parties when one side or the other decides to end it. The most common one is a month-to-month. But they could really be any kind of cycle. And you could have a week-to-week lease or a 2-month by 2-month lease. The way you figure out if it's month-to-month or something else is how often is the rent paid. If the rent's paid on a monthly basis, then you have a month-to-month. If the rent's paid on a weekly basis, you'd have a week-to-week. So the difference between the two, the term lease and the month-to-month, is the term lease has a set end date. And when it ends, it's done unless the parties have really agreed to extend it to do another lease. Okay? Sometimes there's some language in the lease about what's supposed to happen afterwards. So at the end of a term lease, neither side has to give notice to the other that it's ending, unless there's something different in the lease that says they do. Okay? Now with the month-to-month tenancy, because it doesn't end automatically, somebody's got to end it. Okay? And the way it's ended in Minnesota is whoever wants to end it has to give a 1-month written notice to say this is the end date. That notice has to be received before the last rent period starts. So again, the most common one's month to month. And so if the tenant wants to move out at the end of August, the tenant has to get a notice, a written notice, to the landlord by the end of July if rent is due on the 1st of August. Okay? So it's real important for landlords and tenants to know that it's not a 30-day notice. And that's what most people call it, is a 30-day notice. But it's not a 30-day notice. It's only a 30-day notice about half of the year, right? Because we've got a lot of months that don't have 30 days. And so if a landlord or a tenant gives a notice on August 1st to be out August 31st, and they're thinking, hey, it's a good notice, it's a 30-day notice. It's not a good notice. It's actually void. It has no legal effect. Okay? So those are the two differences of the two main types of leases. Generally, landlords and tenants can have in their leases pretty much anything they want. Now you might be thinking, well, when does the tenant get to say what he or she wants? Well, you're right. Most often the written lease is written by the landlord. But they can negotiate. I mean, just like in any kind of transaction, you can negotiate. And it depends a little bit on what the relative bargaining power is. And if it's a tight rental market and the tenant really needs to move into a place right now, then maybe they don't have much bargaining power. If it's a pretty loose rental market and the landlord's got 5 or 6 vacancies and she's having trouble filling them, then the tenant's got more bargaining power. A lot of tenants don't think they have bargaining power, but they do. The other thing is at the beginning of tenancies, a lot of times landlords will do reference checks on tenants. I always encourage tenants to do reference checks on their landlords, and they kind of go, what are you talking about? It's like, well, think about it. I mean, when you pay rent or mortgage, it's probably the biggest chunk of money you pay a month for probably everybody, right? And why should the landlord only be checking on the tenant? I mean, if the tenant's got some bargaining power, the tenant can say, cool, you want me, I'm kind of interested in you. I'd like to talk to one of your current tenants and one of your past tenants. Oh, sorry, we don't do that. Okay, gotta go. And that might actually get the landlord to fess that up. Most landlords are good landlords. Most tenants are good tenants. But most landlords haven't been asked that question, so they might be put off by it. But I sincerely believe that tenants should be reference checking their landlords. Okay. Now, the law, when I talk about the law, I talk mostly about statutes. The Minnesota legislature passes laws, and if the governor signs them, then they become a statute. The law comes from statutes. It sometimes comes from court decisions interpreting the law. Sometimes you've got a statute and it's a little bit unclear about how it should be applied to lots of different people and their court decisions that then say, well, this is how it ought to be applied. So the law kind of collectively means both of those things. Okay, so what does the law say about what can or can't be in a lease? It says very little. Even though there are a lot of laws that cover landlord-tenant relationships, very few of them say what can or can't be in the lease. So you can see leases with like really dumb provisions, and unless they're illegal, they're enforceable in their dumbness. Okay, so what do they have to have in? Well, there are two laws that say leases have to have these provisions, and even if the leases don't, the law kind of implies into these leases that they say this. Okay, what do I mean by that? Well, let's say you've got a written lease, and the lease says the tenant's supposed to maintain the property, keep it in repair. Well, we've got a state law that says the landlord's supposed to maintain the property, and it says that in every lease, that's the landlord's obligation, whether the lease says something other or not. So a lease that says the tenant has to maintain the property, that provision is essentially an illegal term and it's not enforceable. So the law says, and if the lease is silent on who maintains the property, this law basically says you have this obligation, landlord, to maintain the property, whether you've got it in your lease or not. Okay, there's another provision that the law implies into leases, and that's the obligation of both landlords and tenants not to possess illegal drugs in the property. It's not just the tenants, it's the landlords and the tenants. And if the landlord is allowing people to have illegal drugs in the property, a tenant can take action against the landlord. If the tenant is allowing people to have illegal drugs in the property, the landlord can take action against the tenant. We'll talk about those actions in a few minutes. About the only thing that can't be in a lease is that landlords can't have provisions that discriminate on the basis of race or sex, national origin, the general kind of protected classifications. But other than that, in Minnesota, the rent can be $1,000, it could be $5,000, it could be $20. We don't have any regulation of rents. If any of you have come from other parts of the country, you might have heard of rent control. We don't have it. It's more of an East Coast thing and a West Coast thing. It's just not a flyover land thing. So that kind of raises another point, is that if any of you have lived elsewhere and know something about landlord-tenant law from there, it might be the same or it might be different here, because landlord-tenant law is kind of a state-specific thing. There's very little national landlord-tenant law, and so even though there are a lot of similarities around the country, there are a lot of differences too. Yeah.
I've heard the term rent control, but I'm not exactly sure what it is.
Okay. If you could repeat the question so that we have it.
I got a question about what rent control is. Rent control is when, usually it's a city, will say that rents can't go above a certain level for a certain sized unit, and but sometimes they have an ability for a landlord to get an exception to that. So where you see that are really densely populated cities where if there are few vacancies in housing, it would really be a landlord's market, and they could say, well, I've got 10 people for every one unit, I can charge to the ceiling. And so it's an attempt in those areas to keep it down to a more affordable level. Another way to think of it would be kind of the flip side of a minimum wage. We have minimum wage laws so that if you're in an employer's market, that people aren't working for pennies, and this kind of artificially props it up. Rent control kind of artificially puts a rent ceiling on it. Okay? All right. So let's spend a little more time talking about the habitability requirement that landlords have. Because I'd say a very high percentage of the clients I see have habitability problems. So what do I mean by that? Habitability problem doesn't mean a place is uninhabitable. It just means it's not as habitable as it should be. Okay? So if someone has a habitability problem, it doesn't mean the ceiling's caving in, although the ceiling might be caving in. But it could be anything. It's really used to talk about anything that's not as fully habitable as it ought to be. So there can be little habitability problems, or they can be big habitability problems. So the habitability issue, the legal issue, stems from this law that I just mentioned, where landlords have this obligation to maintain the property. And they have three separate obligations that sound kind of similar, but they're different. One is to maintain the property in reasonable repair. Another is to maintain the property in compliance with local codes, like housing codes, health codes, things like that. And the third one is to maintain the property fit for fit by the intention of the parties, fit for the use that the parties intended. Okay, so the last one really refers to, you know, if you have a written lease, that kind of tells you what the intention of the parties are. And so, for instance, if a landlord says you get a room air conditioner and the room air conditioner isn't working, the landlord's not complying with the lease, so the property is not as fully fit as they intended. Okay. Code violations are when you have like a housing inspector or a health inspector come out and they look and they've got a list of all the things that a good apartment's supposed to have, like deadbolt locks and railings along the stairs and screens and things like that. Not all cities have housing inspectors. Okay? So that kind of gets us to the third obligation, which is the landlord's obligation to maintain the property in reasonable repair. So reasonable repair is obviously kind of a vague concept because, you know, your version of reasonable and your version of reasonable might be different. Ultimately, if the parties have a court case over it, it's a judge that decides what is reasonable. And reasonableness can vary from one person to another. Let's give you an example. Let's say you've got someone who's pretty able-bodied, they can walk up and down stairs fine. So the lack of a stair railing might not be a big deal. Okay, well, recently I've had my dislocated toe, and getting up and down the stairs without a railing would have been challenging. Okay? My youngest daughter, who's 19, but she has a couple of disabilities, one's called cerebral palsy. She didn't learn to walk till she was 5. And then it was kind of the Frankenstein walk for a little while, right? So she wasn't walking fully competently till she was probably about 6. Having a railing on those stairs was really important. So when you're looking at a reasonableness standard, it's really reasonableness based on who occupies the property. So what's nice about housing codes is you can be a lot more objective about it. You can just say, okay, you're supposed to have these 50 qualities under our city ordinance, and you only have 40 of them, so this is a problem. So those are the 3 different obligations that the landlords have. It can't be waived, it can't be modified, it can't be contracted away. It's a very firm law that says, landlord, this is your job, and you just got to do it. Okay. So what happens when the landlord doesn't? Okay. And my phone's doing a lot of stuff here, but I'm just going to ignore it. Okay. So let's say it's an annoying thing, but it's not life-threatening. What can a tenant do about it? Well, what they can do is the first thing is to always just go talk to the landlord. And I don't think it has to be in writing. You know, even though I'm a lawyer and I like agreements to be in writing, okay? You know, requests, those don't have to be in writing. So you just call up the landlord and say, you know, I've got this leak going on in the sink, and I'm worried that it's going to start rotting out, you know, the cabinet under the sink, and so I can't stick anything down there. You know, can you come over and take care of it? Most landlords will do it. Most landlords, again, are in the business of having housing that's going to be attractive to people, and it's going to, you know, if it's not going to appreciate right in this market, you know, in general, over periods of time, property appreciates. So it would be kind of self-defeating for a landlord to say, I'm not going to fix up my property, you know, go take a hike. So most landlords are going to do it. So that usually gets the job done. Now, sometimes landlords don't do it, and there can be a variety of reasons. You know, put on my lawyer hat, for the most part, I don't care. If you saw the movie The Fugitive, there's some point where the fugitive says to the cop, you know, I didn't kill my wife. And he goes, I don't care. My job's supposed to get you. It doesn't really matter why the landlord's not fixing it, because there isn't really an exception. You know, they can't modify it, they can't waive it, they can't contract it away. They just have to do it. And so if the landlord says, I don't have enough money, that's not an excuse. Again, there's no excuse. The only excuse would be if the tenant is really kind of causing the problem. I mean, tenant who's maybe trashing the place can't turn around and say, landlord, you got to fix this up like this. That's really the only exception. So there are sometimes there are good landlords that just aren't taking enough time to get it done, or maybe they don't have enough money to get it done, but they still have to get it done. I've been a landlord off and on for about 30 years, and it's a 24/7 job. And landlords who think that it was kind of an easy way to make some money or something, it's really not an easy way to make money. It's a very labor-intensive thing. And if the tenant calls up on 10 o'clock on Sunday and says the toilet's not working, it's your job as a landlord to make it work. You know, and if that means going over and spending a couple hours getting it going or getting a contractor out there, you know, that's the job. So most landlords do it. If they don't do it, then the tenant can then kind of amp it up a little bit. Okay? There are two things a tenant can do to prepare to sue the landlord if they need to. And most tenants will say, oh, I don't want to sue the landlord. It's like, well, and I say, do you want this done? It's like, yeah, I do want it done, but I don't want to sue. Well, if you want it done and the landlord doesn't do it, you know, how are you going to get the landlord to do it? Well, I guess I'd have to sue him. Right. So let's talk about moving in that direction, and the things that you do to move in that direction sometimes get it done. Okay? So the two ways you set up a case to sue the landlord is called a rent escrow case. And one is to send a letter to the landlord saying, fix this thing up, and list all the different things there are. It needs to be in writing. Landlord has 14 days to do it. If the landlord doesn't do it, the tenant can file a rent escrow case in court. The other thing is if the tenant's had a housing inspector out and the tenant wants to, and the landlord doesn't get the things done that the housing inspector lists, the tenant can bring the case based on the housing inspector's report after the deadline passes. So I usually tell tenants to do both. I say, make a list of all the things that are bugging you, send it to the landlord, and you don't have to say anything about suing. You just say, please get these things done. Get the housing inspector out if there is one. Again, a lot of cities don't have them, but if you have one, why not get another look at the property? And then, because sometimes housing inspectors see things that tenants don't, and tenants see things that housing inspectors don't. And so if the tenant does both and the landlord doesn't get them done, the tenant can base the case on both things. Okay? The type of case the tenant files is called a rent escrow case. It moves pretty quickly compared to other types of litigation. You get a hearing usually in about a week or two, and a lot of times the cases are done in about a month or so. So that's the main thing that a tenant can do. Yeah.
So does it cost money to file this? Like, is it a form? Like, in what format do you file? Like,
There is a form, and there's a form that's on the court's website, and it's a fairly simple form. I helped design the form they use, and I wanted it to be something that was pretty simple. It's about a 3-page form, and it kind of prompts you to put the information in that you want. Yeah.
We created one for Zoey. It's one of your attachments that you guys would have received.
Yeah. Cool.
So,
And there is a filing fee. The filing fee is based on what the tenant thinks the cost of repairs would be. If the cost of repairs is over $10,000, which in most cases it's not going to be, it would be the regular court filing fee of $322, I think. If it's below that, it's at the conciliation court level, which I think is maybe around $30 or $50. In any case, people that have very low incomes can get that fee waived.
okay.
Okay.
Thank you.
So that's the main way for a tenant to kind of take kind of affirmative action. But a lot of tenants are thinking about another thing that sounds way easier and way better, but it's not. And it's called withholding your rent. Okay? And you've probably heard conversations about that, probably lots of people that tell you they're going to do it or they've already done it. Well, what's my big beef with withholding the rent? Well, on some level, there's nothing wrong with withholding the rent as a single act in a vacuum. Okay? The nice thing about it is it doesn't take any effort. Matter of fact, you do nothing. You know, you're watching the football game, and now it's August 2nd, you haven't paid the rent, you've withheld your rent, right? So it's very low, it's not labor intensive at all, right? So that's nice, okay? You don't have to send a letter to the landlord, you don't have to get a housing inspector out, you don't have to file a court case, you don't have to pay a filing fee, you don't have to get a filing fee waived. Sounds pretty slick, right? Well, the downside is that when the landlord doesn't get the rent, a very natural response of good landlords and bad landlords is to say, whoa, well, I guess I need to find myself another tenant. And so they file an eviction case. Now, I think landlords that are a little more thoughtful will come and talk to the tenant first before doing it, because the landlord's got to pay a filing fee too. So it's not a freebie for a landlord to file an eviction case. I mean, they got to pay a $322 filing fee. Most landlords are not poor enough to have the fee waived, so that's something they're going to have to pay. Pay someone to deliver the court papers. It can easily be at least $500 to do an eviction case without a lawyer, and then you throw a lawyer in, whatever the lawyer is charging. You know, $100, $200 or more, and that adds up. So most landlords would contact the tenant first and say, you know, what up? And then sometimes that will get things resolved. But a lot of times there are a lot of landlords that will file that case fairly quickly, and then this eviction will follow this tenant around, if not for a short time, maybe a really, really long time. And we'll talk about that whole process of trying to change that a little later on. But that's the main risk of rent withholding, is it leads to an eviction case, and then you're going to court on the landlord's schedule rather than on your schedule. I mean, if you pay the rent, do the letter, do the inspection order, you decide when you're going to file the case, you put it on your calendar. And so when you have the eviction case, it's like you get some court papers, and it's like 7 days from now you got to get yourself into court. And if you don't get into court, you could be evicted a couple days after that. And then you got this record of this eviction following you around for a long time. So I'm not a big fan of rent withholding. The only time I think it makes sense is if the tenant is really thinking, I'm going to split. It's so bad here, I'm going to split. So we're going to talk about that option now, because that is an option. Okay? The option of just leaving. You might be thinking, well, wait a second, you're going to violate the lease if you're leaving. Right? You are going to violate the lease if you're leaving. Yeah.
When you do a rent escrow, when you file the paperwork, isn't it possible to pay your rent then to the court and not to the landlord as part of that process?
Right. Yeah, when you file the rent escrow, it's a good question. When you file a rent escrow, are you paying your rent into court? Yes, you're paying your rent into court. But if you're in the middle of the month, let's say you're not ready to file your rent escrow case until August 20th because the inspector's deadline is August 15th. So what do you do with the August rent? Well, if you say, well, I'm going to hang on to the August rent because I'm going to pay it into court when I file my case on August 20th. Well, sometime before then, you might have the eviction. So I advise the tenant, unless you're really thinking seriously about leaving, you're better off to pay the rent to the landlord on August 1st, file the case on August 20th. You don't have to pay any rent into court when you file the case on August 20th because you've paid your rent. And then the September rent goes into court. There isn't anything really magic in terms of the outcome of the case by withholding the rent. Because the judge in the rent escrow case can say, okay, tenant, you get all the rent you paid me into court for September, plus I'm going to order the landlord to pay you some of your rent back that you paid earlier because this place has been in such bad condition for the last 6 months. So the tenant doesn't make the case any better by kind of exercising control over the money. Because if they do well in the case, the money can come back to them whether they've been hanging on to it or whether the judge is saying, landlord, send it back. The main reason, in my mind, to withhold is if you really think you don't want to pay the landlord because you're going to use this money to help you find another place. Okay? And so, but there's a risk that the eviction would come from that, but that risk may be lower to that person than keeping some money at their disposal to use to find another place. Because for most folks, moving is expensive. And I'm not just talking about getting a moving company or moving truck. I mean, a lot of people don't use moving trucks, they just move their own stuff. But for most tenants to move, they have to be able to float about 3 times their rent to do that, right? Yeah. I mean, you pay the July rent, and you want to move into a place for August. So during July, you've already paid the July rent. You got to pay the first month's rent at the August place in July, right? So now we're talking 2 times the rent. Oh, we want a deposit too. Okay, so that's 3 times the rent. And maybe they want a last month's rent too. So now we're talking 4 times the rent. So in the month of July, you have to be able to spend 4 times what you spent in June just to move.
Yeah.
Because you don't get the old deposit back yet. So for a lot of people with real limited incomes, they don't have 4 times the rent sitting in the bank. They may have like nothing in the bank. And so they are more captive to where they are. And if they are going to leave, it could be the only way they can effectively leave is to not pay that month's rent and to risk the eviction and just split. So there is a sensible reason to withhold the rent, but most often when people are withholding the rent, that's not the reason. They're thinking this is the way to get the landlord to get the repairs done. Okay? So again, 3 different options. One is to pay the rent, get ready for a rent escrow action. The other is to withhold the rent and risk the eviction case, and the other is to withhold the rent and move. Now, when somebody moves, you might be thinking, well, boy, aren't they going to be in a heap of trouble for moving in the middle of the lease? And a lot of landlords, good end landlords, will kind of scare the bejesus out of people by saying, oh man, I'm going to sue you for the last 6 months in your lease, and it's going to follow you around for the rest of your life, and blah, blah, blah. Lots of people say what they're going to do. I mean, I can't tell you how many times someone said, my lawyer's going to call you. Well, they don't have a lawyer, and the lawyer never calls, right? And so I'm gonna sue you for the last 6 months in the lease. It's gonna wreck your credit, and you'll go to debtor's prison, all that stuff. Okay. Well, first of all, we don't have debtor's prison, so we can knock that one off right away. To sue someone for the last 6 months of the lease, the landlord would have to wait 6 months because the rent isn't due from month 6 until month 6. So you can't sue right now for the rent that's due 5 months from now.
What if there's an acceleration clause in the lease?
Good question. What if there's an acceleration clause in the lease? That would change this, although I've never seen an acceleration clause in the lease.
What would
Now,
that look like?
It would be a clause that says that it's kind of like a clause that you would see in a mortgage contract that says if you default on this, all payments due under the contract become due now. Okay? And so then, and the reason for that is you see it much more in commercial contracts. So then it does allow one party to sue the other for the value of the remainder of the contract. Okay? Very, very rare in a landlord-tenant setting. So landlord would have to wait 6 months before they even sue. And then at that point, they'd have to find the tenant, sue the tenant, win the case, find out where the tenant keeps his or her money, and collect it.
Now, can they only do that if the unit has stayed vacant?
I was just going to get to that. You guys are great. So
I told you they were smart.
I'm starting to wonder who's teaching this class. Okay. So the question was, well, what happens if the landlord re-rents? And this varies a lot from different states. But in Minnesota, if the landlord re-rents, the landlord's essentially cutting off the tenant's liability. And that's, in fact, what happens most often. Because, again, that scenario I just painted about waiting 6 months and suing the tenant, I mean, that's like maybe, if you're lucky, you're cashing in a year, right? Well, not a lot of people that own businesses want to roll the dice on something that may or may not happen in a year versus trying to correct it right now. This is what lawyers call mitigation of damages. It's you're kind of cutting off, you're kind of reducing your loss by taking some affirmative step. And by doing that, that also kind of gets the other person off the hook. So what most landlords do is they'll hang on to the deposit, and then they will re-rent the place in the next month or two. And so most often the tenant's liability is maybe the deposit and an extra month, maybe just the deposit. And even if the tenant had some liability and the landlord were to sue the tenant, if the tenant had that housing inspector's report about how there are 39 things that are wrong with this place, the tenant's going to have a decent shot at even getting part of the deposit back. Because the landlord right to collect the rent is connected to their obligation to maintain the property. Okay, they're called mutual obligations. Okay, so whenever the place is under the kind of what its habitability standard ought to be, the landlord's entitled to less rent. Now, what that less rent is, basically judges figure out when both sides are saying, because it's kind of a subjective thing. But for instance, if a place has been condemned, Okay, there's a lot of judges that will say, well, that's not worth anything because you're actually being told you have to leave by the city. And so if you leave and you don't pay the July rent because the place has been condemned and the landlord hangs onto your deposit because you didn't pay the July rent, pretty good chance that tenant's going to get that deposit back because they didn't owe any rent in July because the place was condemned. So in this third option, even though some landlords will make it sound like, this is going to be tenant Armageddon for having done this, it really doesn't play out that way. So what a tenant really has to think about is when they withhold the rent, is an eviction case going to be part of the mix over the next few days or the next few weeks? Because if they don't have any evictions on their record and then they get an eviction right when they're looking at a place, it's going to be on the record and it's going to be hard to find a place. So my general advice to people is to not withhold the rent. And as you can see, this is kind of a complicated conversation. There are various different options for tenants. That's a good time to refer someone to an attorney, okay? Because the attorney can say, what do you want? What's most important to you? Well, it's really important to keep an eviction off my record. Oh, okay, well then we really want to avoid withholding the rent, okay? I've got 4 evictions on my record because my income's been pretty bad over the last few years. Okay, and so if I get an eviction, it's really not going to make things any worse than they are now. Okay, well then rent withholding might be a more viable option for that person because the negatives of another eviction case aren't going to be as big. But you can see there's a bit of a nuanced conversation that goes on there. So that's something that's probably not as strong to refer to a hotline like the Homeline hotline, which is a good hotline, but it's mostly done by students that are supervised by attorneys, and they're supervised well, and they're taught really well. But there's a lot of judgment that goes into this conversation I'm having with a tenant about which course should I go down. And so if someone is in that situation, I think a good referral would be to legal aid, would be to Volunteer Lawyers Network in St. Paul, the Ramsey County and the suburbs there, SMERL, Southern Minnesota Regional Legal Services. If someone's in an emergency situation I'd say referring them down to the Housing Court Project in Hennepin County. If they live in Hennepin County, they can go down there. We have attorneys down there, and VLN has attorneys down there every business day, Monday through Friday from 8:30 to noon, and it's first come, first serve. And I was down there on Tuesday, and we see everybody who shows up. I mean, if they show up at 11:59, that's a little tough. But everybody who's there, through about 11 o'clock or so, we see them, and we can give them that kind of nuanced advice. Okay, now I had a few questions here related to repairs. Actually, most of them were related to repairs. One is, how warm is the landlord required to keep their property? It really varies from city to city. There's no state law that has a minimum kind of winter temperature for an apartment, but a lot of cities in their housing codes have 68 is a pretty common threshold. When that kicks in and when it kind of eases out changes from city to city. So that's really so there are a lot of towns that don't have a minimum temperature code provision, and so the issue there would be is the landlord's maintenance of the property temperature at 66 degrees, is that reasonable for that city, for that part of the state, and for that time of year? Let's see, if landlord isn't fixing things, what can I do? Well, we already talked about that, right? City inspectors found the place unfit. In other words, they're condemning it. What can I do? Okay, that's tough, because if the city's saying nobody ought to live in this place, it's a tough argument to say that I ought to be able to live in this place. The most common condemnation, and condemnations aren't common, but the most common one is when the place really is unhealthy. Like there's carbon monoxide spewing out of the furnace. I mean, I've had cases like that. Or, there's tornado damage and the ceiling is looking pretty iffy, okay? In those situations, the tenant is going to have to move by the deadline given by the housing inspector, and if they don't move out by that deadline, the city might have the police come out. And in that situation, they're really doing it for the health and safety of the tenant. Doesn't mean the landlord's off the hook for the obligation to maintain the property. Again, can't be modified, can't be canceled, can't be contracted away, right? And so even though the tenant has to move out because the property has been condemned, the tenant still might have a case against the landlord for the landlord to either get the place fixed up so I can get back in or pay me to live somewhere else because I've got 3 months left on my lease. Okay? And so condemnation doesn't get the landlord off the hook, but it may mean that the tenant's going to have to relocate temporarily. There are a couple other condemnations that happen. One is if, to be kind of crass about it, the inspector just is kind of fed up dealing with a landlord who ignores and ignores and ignores and ignores. Most city codes will allow the inspector at some point to play hardball with a landlord by saying, we're going to condemn it. I kind of wish they didn't because I think there are other ways they can play hardball with a landlord that doesn't require the tenant to leave. So I'm not real happy about a tenant having to leave in a situation where it's not a health and safety threat. But again, the landlord would still have their contractual obligation to the tenant even if the city's saying you can't have this place occupied. So the tenant could look at suing the landlord in the kinds of cases we've been talking about to force the landlord to pay to put the tenant somewhere else, to maybe actually put the tenant in another unit that the landlord has. Third kind of condemnation is when the landlord doesn't license their property. A lot of the cities that have housing inspectors have a licensing requirement. And it's like the licensing of other professions, like lawyers. We're licensed. Okay? We have to take some schooling to be lawyers. We have to pass a test. We have to take a certain number of continuing education credits each year to maintain our license as a lawyer. We can be disbarred or suspended by doing bad things, but also not maintaining those obligations. Okay? Some cities will have an obligation for landlords to license their property. Nice thing about that is it gets the city in more regularly to inspect properties and to have a landlord come in and basically say on an annual basis that my property is in good shape. Again, not all cities have it, but sometimes some cities will say, well, if we find out you've got a license and you're supposed to have a license to rent, we're not going to let you rent because you don't have a license, and so we're going to condemn the place. Now, I don't really like that strategy because a place that's not licensed might not be uninhabitable at all. It just might not be licensed. And some of the cities are moving away from that. We'll condemn it if it's not licensed. City of Minneapolis is considering an ordinance right now that we've given them some input on to basically disconnect condemnation, kind of an immediate condemnation when a property is not licensed. Because there are other things they can do. They can assess property, they can do fines, they could actually sue the landlord, things like that. Okay, a couple other repair questions I had was air conditioning. Is the landlord obligated to have air conditioning? In Minnesota, no. We don't have any law that says landlords have to have air conditioning. But if the landlord promises air conditioning in the lease or has a room air conditioner when the tenant moves in, then that becomes part of the landlord's lease obligation to the tenant. And if the landlord isn't doing that, remember the 3 different obligations the landlord have: to maintain the property in reasonable repair and compliance with codes and fit for the use intended by the parties. If they've got the air conditioning in place and it's not working, they have now taken on the obligation to provide air conditioning and to repair it if it's not working. And so that's one of the things we have in the Zoey example. And so if the landlord had not had an air conditioner and had not promised it, she would not have the right to insist on having air conditioning. But once it's there, just like the landlord doesn't have to have a microwave, but once the landlord supplies a microwave, then they have to maintain it. Okay? Yes?
What if it's a, I don't know, a 6-unit building and only 2 of them have air conditioning and there was no air conditioning in the other 4? He or she, the landlord, does not have to supply that even though other people in that building get air conditioning?
Right. So the question is, if there are 6 units and the landlord has room air conditioners for 2 and not the other 4, is there a problem there? There is no problem there if the landlord didn't promise air conditioning to the other 4. If the landlord promised air conditioning to everybody and he put in a couple of them and it's like, oh, money got tight and so I'm not going to do it now, then the tenants might have a claim that the landlord's not maintaining it fit for what they intended because the landlord hasn't finished the job. But there isn't any law that says that landlords have to treat tenants similarly. Now, so if you can have different rents for different apartments, and it doesn't have to be kind of mathematically precise. The only exception to that is if the landlord's treating people differently as some sort of type of discrimination. So the 2 white households have the air conditioning and the 4 Somali households don't. That's got discrimination in neon lights. Even if it's by chance, it still looks really, really bad, right? So landlords don't have to treat everyone the same, but they and this comes up quite a bit where the tenant's saying, well, landlord is saying I have to leave because I have loud parties. Well, the tenant down in room 12 has loud parties, and the only reason she's not getting an eviction is because she's a girlfriend of the landlord, okay? And it's like, well, the landlord doesn't have to evict everybody under the same circumstances. So landlord could tolerate the party in room 12 because they're buddies, okay? And not tolerating it in apartment 14 because they're not buddies. Unless there's some discrimination there, okay? They're free to treat people differently, okay? So it all really depends on what the landlord promised and if there's discrimination involved. Okay, we got a couple, let's go ahead.
I've had a couple callers where the problem is if there was a property that had like a condemnation or if there was a serious issue, and landlord's not in the state.
Mm-hmm.
So having trouble contacting the landlord is a big problem that our callers have.
Mm-hmm.
So would you recommend that they still go through like the process in the court system to deal with that if they're not able to actually like get like a landlord on the phone?
Right.
Or if they don't have like a letter that they send, like if like they send their rent to a P.O. box,
Mm-hmm.
what would you recommend to a caller that says, I can't get a hold of my landlord?
Okay, so the question is, I can't get a hold of my landlord, what do I do? And there are kind of 2 variations on that. One, the first part of your question was landlord's out of state. Well, what's problematic with out of state, you can still call up the landlord, you can still send a letter to the landlord. It's a little more problematic to sue when someone's in another state, because generally you have to sue someone in the state where they reside. And so you don't necessarily want to go to California to file your case, to get the screens put on your windows in, Brooklyn Center. A lot of cities require landlords to have a local contact, and so they could sue the local contact. A lot of we have laws that require out-of-state companies to have basically an in-state contact, in-state address, and so most often there is a local contact. And that person can be sued. You might be saying, well, how can I sue the local contact if they don't own the property? Well, one of the things we did a few years ago because of that problem is we went to the legislature and said we need to broaden the definition of landlord in the landlord-tenant laws so that you can really sue anyone who's kind of taken charge of the property. And so when a tenant files a rent escrow action, they can file it at, I always recommend that they basically go against everybody who's connected with the property and let them explain why they shouldn't be in court. Let them go to the effort, I'll kick back and just let them have that argument, okay? So it means the out-of-state owner, the in-state manager, the on-site caretaker, I list all 3 of them, okay? And so usually there is somebody local, okay? So the second thing is, well, what if there's a post office box? Local post office box. That is a problem in some types of cases because you're supposed to sue someone at an address where they can be personally served property, and unless you're the Keebler elf, you don't list in a post office box, right? And so, or the genie from Aladdin when he's in that little tiny little house, but he has big power, right? So one of the things we did with the law for the rent escrow is to say that the landlord can be served by mail, like in conciliation court, if the cost of repairs is under $10,000, and you can mail to a post office box. Okay, so for the rent escrow case, if the post office box is all you've got, you can use that. Okay, and then lastly, there are situations of what I've just kind of said a little bit facetiously is disappearing landlord syndrome. Now, it doesn't happen much, but it does happen a bit in foreclosed properties where this landlord is just gone. They cannot be found. And that is problematic because if you are going to sue, you have to be able to find someone and sue them because the court's just not going to order, the universe to fix the property, right? I mean, there's got to be, Star Trek, they've got to beam into the transporter and be matter, right? And so that's problematic. And a lot of times in that situation, I'll advise a tenant, if the landlord has disappeared, probably you can withhold the rent. If they're probably not going to come back and file an eviction case and pay a few $100 and then go hide under the rock again. So probably the thing you can do is start looking for a place, don't pay rent for a couple of months, build up some money and split, and just deal with the fact that the property's not in good shape.
And Larry, even if the landlord is at a P.O. box and if the tenant can show they've made the service, they file the rent escrow action, the tenant shows up in court, the landlord's not there, but the judge is convinced that the service was good enough, then the tenant is protected because he's got a court order that says either you can withhold the rent or you can apply it to the repairs or whatever. And so the tenant then, he or she has their protection. The landlord then later on wants to file an eviction action because they suddenly woke up. It's not going to happen because the court will protect them.
Right.
Yep. Had another question, yes?
Yeah, what's the actual name of the law as far as you had mentioned mutual obligations, and I see that it's referred to as the covenant of habitability?
Habitability?
So is that actually, if you're having a discussion with your landlord and we're trying to hold them liable to that, what would the actual name be?
Well, the statutes have numbers and titles, and the statute for that one is 504B, I think it's 161, and so it has a statute number. If you were to Google search Minnesota statute 504B, you'd find the whole list of statutes. They all have titles. I think the title of it is something like habitability obligations of landlords.
Okay, well that's exactly what I wanted to know was the statute number. So
It's very commonly referred to as the covenants of habitability.
okay.
And the reason it's got that title is because, again, the law inserted into a lease a provision, and a lot of times contract provisions are called covenants. Okay, another question.
I had a caller actually today who is in a foreclosed property, and I felt safe in telling her that it is foreclosed. She had a sheriff show up a couple of weeks ago with the paperwork.
Yep.
But her landlord keeps telling her that, oh no, it's not going through, keep paying your rent. And she's actually on Section 8, and it takes them a little bit to get new housing because of all the inspections and everything. I told her to call whatever number was on the letter, because there was a 952 number on the letter. And then she was I told her, I said, I'm pretty confident in telling you that it is a foreclosed property. If the sheriff actually came out to your home and served you and your older son, it's a foreclosed property. Now you just need to find out how long you have.
Right.
But, and then I gave her legal aid, but, it was the case of the landlord probably trying to get as much as he could because he's guaranteed so much of the rent, from Section 8.
Okay. So this question raises a few different topics, and that's cool because those are topics I was going to move to in a few minutes. So I'm going to jump ahead to the outline on page 4 that talks about foreclosures and subsidized housing. The question had to do with what happens when a property is in foreclosure. Let's say the sheriff says it is and the landlord says it isn't, and then throw in that it's also a subsidized apartment as well. Okay, so let's just talk about foreclosures a little bit first. And this is an area that has a number of misconceptions that people have. There are three main ones. If you'd ask people that are in rental property that's in foreclosure, and quite a bit of the foreclosed property is rental, and it's generally not big apartment building. It's more often a duplex, single-family home. One person bought a new house, they couldn't sell the whole house, they're renting out the old house, money's tight, which mortgage am I going to pay? I'm going to pay the mortgage on the new house. Mortgage, I don't pay the one on the old house, that one goes into foreclosure, there's tenants there, they want to know what's going on. Okay? The three main misconceptions are, one, it's in foreclosure, I don't have to pay the rent. And that's a misconception because the tenant's obligation to pay the rent is not connected to the landlord's obligation to pay the mortgage. Okay? So even though they're both obligations that people have, they're not connected obligations. And so the landlord can continue to not pay the mortgage payment and still evict the tenant for not paying the rent. Now, is that going to happen? Yeah, it might happen early in the foreclosure process. Foreclosure process takes about 9 months. And if the tenant stops paying rent as soon as they get those papers from the sheriff, the landlord's still going to have ownership interest in the property for about another 8 to 9 months. The landlord may very well file an eviction case against the tenant in month 1, even though it costs a few $100 to do it, and then get another tenant in and get a little cash flow coming in. Now let's fast forward to month 8. Let's say we're a month or 2 away from the end of the foreclosure process. Is the landlord going to file an eviction case against the tenant when they're not going to own the property in a couple months? Unlikely. And so the tenants in that situation have a little bit of an option toward the end of the foreclosure process to say, I'm not going to pay the rent because the chances of me getting an eviction aren't real strong. So what is this foreclosure process? Because that's kind of confusing. The sheriff delivers some court papers. It says property's in foreclosure. It's tough stuff to read, even for lawyers. If you're not a real estate lawyer, you look at it, it's got lot descriptions and it's got all kinds of stuff about, the legal terms about foreclosure. I mean, how many of you guys know your lot description? Tell the truth. No. Okay. All right. Well,
I used to work with a title company.
okay. So we have one teacher's pet here who knows her lot description. Okay. I'm a lawyer. Do I know my lot description? No. Okay. These foreclosure notices have lot descriptions on them. So sometimes tenants are looking at it and they're going, well, this is a stack for the landlord. I don't need to look at it. Okay. But it comes. And it says, we got a foreclosure sale in 2 months. And it's at the sheriff's office. And so the tenants are thinking, well, I got to leave. I mean, we got something going on in a couple of months. I don't want to get an eviction on my record. Okay, well, they don't have to leave before that foreclosure sale. That's a sale date. In Minnesota, the sale is in kind of the front end of the foreclosure process. In other states, it's at the back end. So it's at the front end. Well, what happens after the sale? Well, usually the bank comes in and they say, well, there's nobody else here. We'll bid at the amount of the mortgage that's due. Then there's a 6-month redemption period, which the owner, in theory, has the right to come in and settle up things with the bank and keep the property. It doesn't happen much in single-family duplexes. Larger commercial properties, big apartment buildings, maybe. So it's a 6-month period that essentially the landlord still owns the property. Nothing has changed in the relationship because of that sale. The only thing that's happened is now the bank's on deck. They're on deck to take over the property 6 months from now. So the tenant doesn't have to move out before that sale. They basically can stay for this whole foreclosure process, and they can even stay after because the bank has to take them on as a tenant when the bank picks up the property at the end of the foreclosure process for a minimum 90 days. And it may be longer if the lease runs longer. So a lot of tenants are thinking, bam, I don't have to pay the rent. Wrong. I have to leave right away. Wrong. They can basically, from the time they get that foreclosure, they could very well be on the property for another year. So the big thing for a tenant is to not do anything rash, to go talk to a lawyer and find out what their options are. Now, this third misconception is the landlord doesn't have to maintain the property because the bank's taken it over. Wrong again. The landlord-tenant relationship doesn't change until the last day of the foreclosure period, and then just shifts over to the bank. So the landlord's got to maintain the property, that whole redemption period and everything, they got to maintain it. As soon as the bank takes over, they got to maintain it. And so tenants should not just be accepting the landlord's not maintaining the property, and they could do all the things that we've talked about so far. You might be thinking, well, why should they sue the landlord if the landlord doesn't have any money? Well, just because the landlord's in foreclosure doesn't mean they don't have any money. It just means the one bill they're not paying is the mortgage on the rental property. They may have all kinds of money, or they may be hurting, but they probably have virtually nothing. I mean, it's probably not the situation. So the tenant could use all the remedies we've talked about before, and judges aren't going to say, oh, well, the property doesn't have to be maintained because you're in foreclosure, because again, there's only one exception to the habitability requirement. That's when the tenant's trashing the place. Okay? So the fact the landlord's in foreclosure is what lawyers would say legally irrelevant. It's not something that has any relevance to what ought to happen with the case. Now you added one more component because that hypothetical was not complicated enough. You added one, which was Section 8. Have all you guys heard of Section 8?
Yeah.
Okay. Section 8 is one form of subsidized housing. There are a lot of different types of subsidized housing. It's the one that people have heard about the most. It involves tenants who go to a housing authority. They wait a long time. You know, if anyone thinks, oh, just go down and get that Section 8 voucher, you know, it'd be like waiting in line for the Springsteen concert that's not tomorrow night, but 5 years from now. Okay? So it doesn't happen fast. People wait a long time to get it. Why? Because it's really valuable. Okay? It converts a property that would rent way outside a tenant's income range to 1/3 of their income. That's pretty sweet. Okay? And so it's a nice thing to have. The other types of subsidized housing, public housing programs do similar things. What's unique about the Section 8 voucher program is a tenant can then go into the community and find a landlord that wants to rent to that person rather than just stay in a particular structure, which is the other types of programs. So what's risky for a tenant who's got this voucher is the risk of losing the voucher because it's so valuable. I mean, if your income is $500 a month and you have this voucher, you might be paying $150, $200 a month for rent. You lose that voucher, you're probably looking at having to pay rents that are way in excess of your income. And so then you got to double up, and that's all complicated and everything. So tenants with Section 8 vouchers always need to make cautious decisions so that they're not kind of getting into a territory where the Section 8 office might be saying, hey, you're violating your lease, you're violating your rules. So that whole conversation we had about rent withholding earlier, I really strongly discourage people with Section 8 vouchers from withholding the rent because that can lead to an eviction action. Well, what about withholding the rent and moving? Well, that might be violating their lease by moving early, right? So the person with a Section 8 voucher is a little more captive than other folks because if they make some decisions that can violate Section 8 rules, they might lose their voucher. So whenever anyone is in a Section 8 situation and they're looking at either an eviction case, they're looking at maybe breaking their lease, trying to weigh some options, they really should talk to a lawyer who can kind of have, again, a more nuanced conversation about what those things are. It's one thing to say, because it's factually correct, the landlord has to maintain the property in reasonable repair in Minnesota. You can say that. You don't have to be a lawyer to say that. I can say that. Anybody can say that. Okay? But when you're really weighing 3 or 4 different options, and some have risk and some have less risk, you know, you really want to have a lawyer doing that because, you know, like I'm at the doctor today and I had my toe dislocated and I had this pin in my toe, and without going into a lot of details, today was the day for the pin to come out. Well, do I want anybody else taking out that pin? No. I want a professional doing that. Okay? Now, could a non-professional say, well, you know, it's pretty common in toe dislocations to have a pin in your toe until it gets set? Sure, factually correct. Okay for a non-doctor to say that. Okay, so whenever you're looking for a really nuanced kind of analysis, I think that's when you want to be saying, okay, let's go to legal aid, volunteer, you know, lawyers network. You know, talk to a lawyer who can really kind of weigh those things.
Yeah, because I gave her the Section 8 office.
Yep.
She has her thing from because I told her she'd want to let them know.
Always.
And then your guys' number, and then told her to call the number on the letter because that's usually what we
Yep.
tell them to do is
Yep.
call what's on the
Yeah.
notice.
But it's real common for both good and bad landlords to be in denial of what's going on with foreclosure, and to say, I mean, they might be trying to pull something over in the tenant, or they might not really have come to terms with the fact that they're going to lose this place in a few months. And so, real common for folks to say it's not in foreclosure. If they get something from the sheriff that says it's in foreclosure, it's in foreclosure. Now, it's possible the landlord might be able to avert the foreclosure by selling the property or something like that, but that's something that the tenant could verify with the sheriff's office. Yep.
And I told them that too, and she had the sheriff's card, so.
Okay. I had one other habitability question that I wanted to deal with, and then I'm going to go through some other topics in kind of a little more swiftly, and that's bed bugs. Everybody likes to talk about bed bugs, right?
Huge issue.
Okay, let's all scratch our heads a little bit, okay? Bed bugs are, you know, they're creepy, okay? after my first bed bug case, every time I had an itch, it was like, oh no. Well, I didn't have bed bugs, but you get paranoid about it, right? So what are bed bugs? Well, bed bugs are really, really small. They're really, really hungry, and they're really, really sturdy. And so they don't have to, try not to gross you out here, but they don't have to dine often. Okay? So you know what they dine on, right? They dine on us, right? And so the problem with bed bugs is that, besides them being creepy, is that they hang around warm areas where we all are, right? They tend to be more likely in couches and beds because that's where we tend to be for a while, and our warmth they enjoy, right? But they can kind of be patient for us to come back. And so you can't wait them out, right? They'll wait you out. Go on vacation, they're happy to see you when you come back, right? And so the other thing that's problematic, though, is that not everybody's allergic to them. So, one person may get bed bug bites and they show, and other people don't. Same with bees. Some people have really intense, life-threatening allergies to bees, and some people can get stung up the wazoo and they just put on some cream and move on, right? And so same thing with bed bugs. So it makes it really hard to figure out the ultimate question in bed bug cases. Who brought the bed bugs, right? And so often the landlords are saying, well, tenant A brought the bed bugs because she moved in, we never had bed bugs before, and now we got bed bugs. Well, maybe she did, maybe she didn't, because maybe tenant before tenant B had bed bugs but wasn't allergic, and so didn't complain about them. And so there wasn't any evidence of bed bugs until A came in because A's allergic, and so she's showing the signs, right? And so it's very difficult to prove where the origins of the bed bugs, And so you might be thinking, okay, well, that's kind of a 50-50 for the landlord and tenant. Well, actually, it's not, because it's the landlord's obligation to prove that the tenant caused the problem. Again, it's the landlord's obligation to maintain the property. The only exception is if the tenant is causing the problem. So in a court case, the landlord has the burden of proving that the tenant caused the problem. And if it ends up being a 50-50 case, the thing that lawyers will tell you is that when you have a general burden of proof in a case that's not criminal, you got to do a little better than the other side. And if you come equal to the other side, you lose because you had the burden of proving it. So, usually these things aren't done mathematically, but it kind of means I gotta win 51-49. If it's a 50-50 tie and I'm the person who's got the burden, I lose. And so in a case like bed bugs, since it's very difficult to prove who caused it, landlords, when it's litigated, actually have a difficult time saying that they don't have the obligation to remedy it and that the tenant has to pay for it. Okay? Usually, the court decisions are going to be the landlord has the obligation to deal with it, landlord has to pay for it. Now, a lot of landlords think it shouldn't be that way because it's a vexing problem. The best way to get rid of bed bugs is to basically superheat them. You might have heard of this a little bit. The chemical stuff doesn't really work all that well. The superheating, you basically heat an apartment up to about, 150 degrees, something like that. It doesn't melt anything, doesn't hurt any of the electronics, but the bed bugs like warmth. They don't like that much warmth, though, so it kills the bed bugs. But it's expensive. I mean, think about, it's just expensive to cool your apartment down to 74 degrees. Think about closing it off and heating it up to 150. It's like you got to bring in some special equipment and do it, and it's pricey. Some landlords, big landlords, actually have purchased them so that they have them there. So the bottom line with bed bugs is that they really aren't any different than any other landlord property maintenance issue. It's just a lot of people think it ought to be different because it's a little hard to get your head around what to do with it. But it's the landlord's obligation to really deal with the problem and pay what needs to be done to get it done. Yeah.
Is it a different process if you're in public housing, though, for that issue?
The question is a different process if you're in public housing? And the answer is no. It's not a different problem. It's not a different process. Public housing, Section 8 landlords, they all have the same general maintenance obligation. And the only difference in public and subsidized housing is, I think, if the landlords get the tenant thinking that they don't have any options, then the tenants don't enforce their rights because they're worried about it getting evicted, they're worried about losing their subsidy. But the short answer is the landlord in public housing, Section 8 housing, has the same obligation to treat bed bugs, to fix the stove, to fix the plumbing, to have the screens on the windows than anybody else.
So how many times can a landlord chemically treat bed bugs before a client can do a rent escrow because they're just not going away, but they refuse to do the heat because it's too expensive?
Okay, how many times does a landlord get to try to fix the problem, bed bugs, with chemical treatments before the tenant can file a case about it? Tenant doesn't really have to wait. If the landlord is trying to deal with the problem, that's great, but the law doesn't have as an exception for the good-hearted but unsuccessfully treating landlord. Again, only exception is the tenant's causing the problem. And so it's nice and it's great they're working on it, but it's basically, it's really an ends-oriented thing. The goal is the property is supposed to be maintained in those 3 different ways, and if the landlord's trying and not getting it done, and the tenant's fed up waiting, they can take that action. Had another question?
Yes. What about someone that lives in a mobile home park,
Mm-hmm.
and there's someone that's supposed to take care of the mobile home park? I don't know how if that's
Yep.
different because they're not renters and they own the mobile home.
But they are renters.
Oh, they are. Okay.
Because what they're renting in a mobile home lot is they're renting the lot space on which the mobile home sits. So most people in mobile home parks, manufactured home parks, if you're old enough as me, you know trailer parks from the old Roger Miller tune, trailers for sale or rent. Okay. Excellent song, yes. Not as good as the Buffalo Field one, but anyway. Most people, they own the mobile home, but they rent the lot space on which it sits. So the park is a landlord for the lots and for the infrastructure of the park. So there's like plumbing and electrical stuff that comes up to the mobile home. The mobile home connects up to it. There are drainage issues. There are streets within the parks. The park owner has to maintain all of that. The park is not obligated to maintain the mobile home because someone else owns the mobile home. Now, if someone rents that specific mobile home from the owner of the mobile home, then you have 2 different leases going on. The owner of the home is leasing from the park the lot space on which it sits, and then that person is renting to another person the mobile home. So that person who owns the mobile home would have a landlord's obligation to maintain the mobile home for the use of the person who's renting it. Now, sometimes mobile home parks will own some of the mobile homes. They may buy them from tenants that left, from people that left them in the park, and then might be renting them out. So you do have people renting mobile homes now and then, but it's much more common for people to own them and rent the lot space. Mobile homes that sit on a person's land, which is real common outside the Twin Cities where I used to live, that someone might have used to have the mobile home, then they built the farmhouse, and now they're renting out the mobile home, then that's just a regular landlord-tenant relationship. Okay? But there are a lot of problems that are unique to mobile home parks. We had a case in our office where there was a really bad flooding problem, and the mobile home park wasn't really doing anything else. So we filed a rent escrow action against the park over its maintenance or lack of maintenance of that infrastructure.
Okay, because I had the caller. She said she kept everything pretty clean. She owned the mobile home, but there was an abandoned mobile home that was next to them that had garbage, rats, with a whole, ordeal. And they got in touch with the person that is supposed to take care of the park, and he said it wasn't his responsibility. So
Yeah.
I gave her legal resource, legal aid, the health department, and I forget the other place.
Yeah, that's a tough situation because the question was, well, what about the abandoned mobile home next door that's basically becoming bad news for the person next to it? And it's not owned by the park, it's owned by somebody who's not there. It's not the park's obligation to basically maintain that mobile home, it's the owner's obligation of it. And so in that way, it's not a whole lot different than non-mobile home parks where you've got house A and house B is vacant and it's not being maintained, and that's causing problems for house A. So I don't know a lot about this area, but I know that there are types of cases called nuisance cases that people can file when someone is creating an adjoining nuisance to them. And so that might be a remedy for that person that a lawyer could discuss with them. Okay, so we've got about 15 minutes left. And I'm fine that we spent a lot of time talking about habitability because it really is the chief concern of the tenants that I deal with, that's habitability. But let's talk about a few things relatively quickly. I've got on page 3 here, in a lot of times in duplexes and triplexes, there might be a single utility meter for several different units. The law generally requires the landlord to be the bill payer on that. There are some exceptions to that rule. If a lot of times tenants don't know that there's any problem with shared meters, and so that's something they should talk to a lawyer about because the landlord might be doing it legal, but the landlord might not be doing it legal, and then the tenant has some remedies if they're not. Privacy is it's a little bit of a misnomer, the tenant privacy law, because when I think of privacy, I think of being able to kind of control your surroundings and kind of keep things private. And all the state privacy law really does is it requires landlords to give notice before they come and see a tenant. It doesn't have to be a written notice, it can be an oral notice, it just has to be a reasonable notice, and the landlord's supposed to do it before they come in unless it's an emergency. The tenant doesn't have the right to say landlord can't come in. So it's really not privacy, it's really kind of a landlord notice I'm coming law as opposed to a tenant privacy law. A lot of tenants think they have the right to keep the landlord out, and they don't. Okay? Security deposits, that's probably the second most common dispute among landlords and tenants after habitability issues. The landlord has 21 days to figure out what he or she's doing after the tenant leaves and gives a forwarding address. The 21 days doesn't start until the tenant gives a forwarding address. Then the landlord can withhold it if the landlord thinks that he or she has some good reasons. The main good reasons would be if the tenant owes money, like owes some rent, or if the tenant had damaged the property beyond ordinary wear and tear of the property. Ordinary wear and tear is an easy thing to say. It's a hard thing to show because properties deteriorate a little bit over time. So the law isn't that the tenant has to leave the property the exact way the tenant found it, because properties they fall apart a little bit. So the standard really is, did the tenant do some kind of special things that make it fall apart a little more? Cigarette holes in the carpet, okay, probably the tenant's problem. The fact that the screens don't work as well as they used to, but they're not broken, probably the landlord's problem. Okay, so the whole business on deposits, it's a very kind of tenant-specific thing as to whether a tenant's got a good claim or not. But that's still, even though it has some nuances to it, I think it's a really good topic for non-attorneys to give advice on. I think for tenant hotlines and stuff, that's a really good referral because, to be honest, where I work, it's a lower priority because the higher priority cases are people's utilities getting shut off, getting locked out of their place, they got an eviction case tomorrow, the ceiling's caving in. That's a higher priority than my landlord didn't return my deposit, what do I do about it? And so that's a good, a referral to legal aid just for a deposit issue is they're probably going to find from legal aid, we don't have time to help you out with it. So much better to give that to like a tenant hotline service. We talked about foreclosures, public and subsidized housing.
Now, I have a quick question on the shared utilities.
Yep.
If a tenant moves in under the understanding that it's a shared utility, they're in a duplex, and upstairs and downstairs pays the landlord X amount of dollars. If he had it in the lease at an X amount of dollars, or whether he gives them a bill each month. What if in the case one day the utility shows up in one of the tenant's names because the landlord no longer wants it in his name? Can he do that or no?
Okay, the question is, can the landlord just shift the utility obligation over to the tenants? And that's kind of separate from whether it's a shared meter or not. Can they do that? And this is one of those areas where I'll have to say, I'll tell you what the law is, and I'll tell you what really happens in the real world and what people can do about it. So the law is that the landlord, if in their lease, their obligation is to do the utilities, then they're breaking the lease when they shift it over to the tenant without renegotiating the lease, giving something to the tenant in return. So the short answer is no, okay? But there are all kinds of times when people do things that they're not supposed to do, whether you drive 60 in a 35 zone or whether you tell someone you're going to do something and you don't, okay? So unfortunately, the major utilities in town, they get the call from the landlord, shift it over to the tenant, they do it. And it really bugs me that they're doing it, because if the tenant calls up and says shift it over to the landlord, do they shift it over to the landlord? No. Right? Now, I don't mind if they do it the same for both, but they're not doing it the same for both. They're kind of saying, well, tenant, prove to us you're shifting over to the landlord, show us the lease. Landlord calls and says we're shifting over to the tenant. I think they ought to say, show us the lease. Right? So the landlord shouldn't do it. It's a violation of the lease for the landlord to do it. Unfortunately, the utilities often effectuate this landlord's breach of the lease. So then what's the tenant need to do in that situation? Well, the tenant could file a rent escrow case against the landlord. You know, they probably wouldn't be able to get a housing inspector out on this because this isn't a housing inspection thing, but they could send a letter to the landlord saying, you need to tell the utility company to put this back in your name because you're violating the lease. And if they don't, they file a rent escrow case and get the judge to order the landlord to shift it back. Now, another part of the question had to do with shared meters. And what I just said about non-shared meters would be the same answer for shared meters. Okay? The difference in shared meters is that the landlord has an obligation because it is shared. So the problem with shared meters is that your bill is somewhat dependent on what other people do because it's shared. Right? And so there's some protections in the law so that people don't get sucked into shared meters without knowing that's what they're getting into. So the law requires the landlord to disclose that it is a shared meter situation before the tenant rents. The landlord has an obligation to show the tenant the usage over the last year so the tenant can kind of figure out, okay, what am I getting into at this place? Landlord also has an obligation to show the tenant the bills that are coming in as they come in. And lastly, the landlord's got to have a fair way of equitably distributing each bill. And so the most common problem I run into is the landlord says, okay, electric bill, tenant A, you pay that for the whole unit, and tenant B, you pay the gas for the whole unit. Okay? Well, both of those are illegal shared meters because they have to divvy up each bill, not just say, you take one, you take the other, and we'll call it a wash. So that's the most common problem with shared meters. But most tenants don't even know they have a problem with a shared meter because the landlord says this is the way it is, and they just do it. And so it's pretty common that they only figure out there's a problem with it when they come to see me about something else. And I say, well, you in a duplex? Okay, tell me about the metering. And then I find out they got a shared meter and the landlord's not complying with it.
Well, the reason I ask is because usually, well, coming this winter, we'll get calls from people who their landlord just switched over the utility into their name because it's at $5,000 and, you know, they know that the tenant could possibly go to, you know, heat share or energy assistance and get assistance with that. But at the same time, are they even, you know, how can they switch a utility into one person's name if it's supposed to be for 2 units?
Well, the question is how could a landlord shift utilities for 2 units into one person? Well, first of all, my first answer still stands, that if the obligation in their lease relationship is the landlord's supposed to be paying, then the landlord's still supposed to pay unless they renegotiate it. And so you just see a lot of funny things with utilities, and so that's one area where it's good to have a lawyer take a look at it because you know, you want to look at what their lease relationship is. You want to look at if it is shared meters. You know, just it's a more nuanced thing. We're running up a little short on time, so I want to do a quick finish.
Yeah, if you could maybe address Zoey real quick,
Yep.
and yeah, that'd be great.
So one more thing before Zoey is there's a kind of a long section here on evictions, and the reason why it's a little bit long is to just let you know how complicated it is. When anyone has an eviction case, they should talk to a lawyer because it's not as simple as did you pay the rent or not. We've talked about habitability, we've talked about licensing, we've talked about shared meters. All those things are relevant to whether a tenant owes rent or not. And then there are all kinds of procedural issues that come up in court cases. So you really need to talk to a lawyer. I very commonly see people that say, I got this rent case and I don't think I have any defenses. And I talk to them for 20 minutes and I want, you got 7 defenses here. So let's talk about how we're going to do this case. Okay? So what about Zoe? So we already talked about the air conditioning thing. Since the landlord has provided the air conditioning, she's got some remedies to deal with that. Because she's on Section 8, I'd say rent withholding is not a good idea for her, because if she does rent withholding and gets an eviction case, that may cause her some problems with Section 8. I don't think it would be a good idea to just pack up and leave, because that would cause problems with Section 8. So she could say, she could give, and because air conditioning is not required by local codes, there's no need to get a housing inspector out for that. She still might want to get a housing inspector out because there may be other problems there. But in terms of the air conditioning, it would be send a letter to the landlord, say deal with the air conditioning. If the landlord doesn't deal with the air conditioning in 14 days, then she files a rent escrow case, tries to get a judge to order the landlord to deal with that. She could also raise the privacy issue in her letter and raise that in the case. Again, she doesn't have the right to just privacy, but she had the right to notice that that person was coming so that she knew and wasn't doing stuff that was going to be, really embarrassing for her. And I can't remember if we had something. Those were kind of the main. Oh, one of the things she was thinking about is just packing up and moving to the burbs. Again, if she leaves early, she runs the risk of hurting her Section 8. But the other thing is that, the burbs are not necessarily better than the city. I mean, I live in the city, and I grew up in the burbs, and I lived in small towns and stuff. I mean, the landlords aren't better in one place than another. I mean, they're crap landlords in all places, and they're good landlords in all places. And so the real thing for her is if she's looking at moving, to do some reference checks on the new landlord to see if she gets a landlord who both has a name that's not as foreshadowing as this landlord, but then also a good landlord. Was there something else I was supposed to say about Zoe? Or?
She couldn't was asking for her, wasn't sure about how to ask for her lease, because she was afraid that he was just going to fabricate one.
Oh, yeah. That's tough. I mean, if there's probably some chance the landlord would fabricate one, but this landlord in this hypothetical is not exactly a light bulb, right? Okay? The idea that he would just kind of come up with a totally new lease, it's certainly a possibility, but there's nothing to lose for her to ask for the lease, to at least see if he's coming up with something that's different. He might very well come up with the same one. If he comes up with something different, then she can start talking to a lawyer about how to deal with that. So I don't see any downside to asking for the lease.
That's usually what we tell our callers.
So the big thing to think about is, in all the things we've talked about, some of the stuff is a little more factual. Landlord has an obligation to maintain the property, can hang on to the deposit for 21 days. There are a lot of things that are factual that aren't real nuanced, and those are fine things for anybody to tell somebody else, whether it be you or anybody else, and for hotlines to do it. When you're getting to the more nuanced things like withholding rent, habitability issues, foreclosure, shared meter stuff, evictions, those are better to get to a lawyer so a person can really kind of size those things up. If it's more of an emergency thing, then I'd say have them go down to the housing court project where we can see, you tell someone to go to housing court project tomorrow, they'll see one of us tomorrow. And there's a nice turnaround time for that. If it's a non-emergency thing, I wouldn't tell everybody to go there, because then we'll just have lots of people down there, and then we'll have to try to triage which ones are emergency ones and non-emergency ones. So for the non-emergency ones that really need more nuanced advice, they should go to kind of the intake lines at legal aid and to maybe the, and volunteer lawyers network would be good referrals for them.
And let me just make 2 really very quick points here. To double back on what Larry just said, is that I really think that it's exceedingly important that you're listening closely with the callers. And is it an emergency versus non-emergency? And the best way to figure out emergency is, are they at the risk of losing shelter? Okay, is this a shelter issue? If their dishwasher is not working, that's not a shelter issue, and that is a home line thing. But if they are at immediate risk of shelter, emergency, all right, what we want is we need to get them to a lawyer. So to housing court, and that is, they're talking to a body, and then you guys sometimes refer them out and you go full representation with them, or you get them to the right place. And over in Ramsey, it's more limited, but they do have housing court clinic over at the Ramsey County Courthouse. Smurls will help them. Smurls also has attorneys, I think, once a week, volunteer lawyers that will see people on a clinic basis, but people have to call to get organized. The great thing about the Housing Court Project is you don't need an appointment. It's really show up. Just make sure you make it. And remember, the callers are going to be inconvenienced. They're going to say, well, I want to see a lawyer right away, or I want to see him or her on my terms. Well, everything has a trade-off. The other thing is, and I want to just go back to one of our themes from our training, carry over from the first session till now, which is, remember, if it's a small problem now for your caller, you want to make sure you urge them to see a lawyer now before it becomes an emergency where they lose all their options. Okay? We have run out of time. Larry has done a great job. Thank you so very much, Larry. You've been wonderful. So thank you.